late this morning. I thought it started later, but let's get into Afroman. It's already begun. I hit the wrong button this morning too. Holy shit. Having some technical issues this morning, but let's get right into Afroman. No more waiting. Let's just get right into Afroman. The trial has already started. Let's get right into it.
From time to time?
They do.
You've worked with kids for how long?
30 years.
You've got into the mind of kids pretty well.
Yes.
When they would play Mr. Foreman's song Lemon Pound Cake, did they take that as a literal fact from your observations?
No.
Were they laughing and joking about it?
Oh, yeah. Absolutely.
Are you familiar with the song WAP?
I think I've heard
Oh, sorry,
it.
no, strike that. I'm going to give you the complete song
Yeah.
and then summarize it because I only want to say it once. Are you familiar with the song Wet Ass Pussy?
Yes,
Is that a rap song?
it is.
Has your students played it in class?
Once, and I asked them to please turn it off.
When they were listening to it, did they think that was fact?
No,
So they didn't think that that was depicting anything in real life?
no,
So you didn't have to teach them that wasn't real?
right. No, I did not.
You've heard the song, correct?
Mm-hmm. Yes.
Do you believe it's a literal interpretation?
No,
Would you agree it's derogatory towards women,
no,
even though it says nasty things about them?
yeah, no. I mean, it's the artist's opinion, I guess. That's the way I feel.
Maybe not an opinion you like, but
Yeah.
you're not going to have one. Go ahead. So, Ms. Grooms, has Mr. Foreman's posts about Sean or any of the general posts about the Adams County Sheriff's Department as a whole affected your life any at all?
No,
Would you believe it would have affected your life while you were married to Sean?
if it had any effect, I guess that would be the time it would have an effect.
But as his spouse, you would have expected it.
Yes,
Okay. And I don't want you to go into too many details, but is it fair to say that Mr. Foreman, the posts about the police department, everything had not a damn thing to do with your relationship between you and Sean and why it
No.
came to an end?
no, it did not.
So the posts never affected your life, never affected your marriage?
No,
Okay. So any statement to the contrary would be false?
yes.
Okay. Thank you very much. No further questions at this time, Your Honor.
Thank you.
Morning, Ms. Grooms.
Good morning.
I'm sorry you have to be here.
I am too.
Thanks for coming. Where to start? You never sought a protective order against your ex-husband, did you?
Yes, I did when we divorced. The divorce, yes. I
Did
had a
you?
restraining order.
Did you got a restraining order?
Yes, I did.
Were you aware of the posts that were coming out after 2022 about the sheriff's deputies and calling them thieves and that sort of thing? Did you ever see any or hear any of the songs?
Some of my students referred to it and they would say, I saw your husband in the video. And I would say, yeah, that was him, and turn around and walk away. I didn't elaborate on any of that, no. And
What?
they didn't either,
Why didn't you elaborate on it?
because I didn't think it was the student's business.
Okay, so they had seen your husband in videos,
Yes,
and did you tell your husband about that?
about,
That your kids had mentioned it?
no, it was just a mention and that was it.
Okay. Did you ever, you saw the posts yourselves or videos yourself, or did you just hear about it from kids?
I saw part of it and then I heard about it.
Okay. And Did anyone else in the community ever say anything to you about these videos or posts?
No.
Just your kids?
It's my students in the school.
Students? Okay. The song that Mr. Osborne asked you about, does that song refer to a specific identifiable person?
I don't think so.
Those are all my questions. Thank you, ma'am.
Rhonda, Mr. Klingler asked you about your students. Your students saw the post
Yes.
and they articulated it to you?
Yeah, just say, hey, I saw your husband in this video.
Students can, would it be a fair statement to say children can be mean? Cruel?
Absolutely.
You've seen instances of them being cruel?
Absolutely.
Are they cruel to both other students and teachers?
Yes.
I don't like bringing up sensitive subjects, but has any of your students ever been cruel to you in the past?
Oh, yes, definitely.
Would it be fair to say they've said some pretty mean things?
Yes.
You see, I'm trying not to ask you what they are, but are they shocking names?
Coming from my students, I mean, in all honesty, it's, when they're mad at me because they didn't receive an A, yeah, they get mad.
And they
And-
lash out.
Yes.
But they're not calling names a fact or anything to
No,
you.
no,
And they've seen these posts.
yes,
Did your students treat you any differently?
no.
So could you point to any instance where a student treated you differently due to the posts?
No.
I'm gonna ask this question. You said you're sorry to be here. Why are you sorry to be here?
Because from my recollection, my ex-husband had said that this was part of the reason we got divorced.
No further questions, Your Honor.
Klinger? Mr. Osborne, am I right to understand this witness was a lay witness?
Pardon me?
This was a lay witness, not an expert, right?
She's a lay witness to testify to what she would have experienced in this.
Right. And the only reason I did that is to explain to the jury that people sometimes have training experience and can make opinions as experts. The doctor comes in a medical malpractice case, they're an expert. This is a lay person, the same as any other. Some of the questions spoke generally about society and public perception, which would seem like more of an expert opinion, when in fact, as a lay witness, she can only testify about what she experienced herself. So you have to understand the scope. She's just what happened to her, lay, average person, not educated expert. Thanks for being here. You can have the excuse. Go ahead, Mr. Osborne.
Your Honor, I asked for a short 10-minute break so I can talk with Mr. Foreman. Based upon the ruling in the Rule 50, I want to juggle some of my witnesses, make some corrections to that, as I had anticipated a different verdict due to the evidence, or different ruling due to the evidence, so I'm going to need a shift for that. I'd like 10 minutes to consult with my clients to strategize on that.
Comments, Mr. Klinger?
No, I have no objection to that, Judge.
If you're doing well managing your time, I think that's a good idea. I would like to know how it went with like getting the jury on schedule.
Your Honor, that's why I want to strategize, see how we can hopefully.
Yeah, no, I appreciate what you're saying. Take a break, go back to the jury room, stay there if you would please. Short break will be helpful.
Joe, follow me up, please. exhibits, Judge.
So it'll be admitted without objection. Rebuttal, please.
No rebuttal, Judge, no further witnesses.
Okay, thank you. So, ladies and gentlemen, we're moving forward to the point where you get the case handed to you. What comes next is closing arguments and instructions of law. So closing arguments are meant to be the opportunity for the lawyers to tell you what they think the evidence means. If you want to take notes, do so, but like draw a line on your paper and say argument, not fact. Like I don't know how you keep notes, but I have to keep them organized. So I can realize who's talking. You've seen me do it a couple times. Lawyers aren't evidence. The witnesses are. It's the same thing here. I don't think you would get confused or misunderstood. The plaintiff goes first because the burden of proof is on the plaintiff. The plaintiff also, because of that burden of proof, gets a privilege. So they get not only the first word, but they get the last word. So Mr. Klingler would start, Mr. Osborne would go second, and then Mr. Klingler would get the last word. Not because of favoritism or anything else, but because of the burden of proof. Then at that particular point in time, we'll give you jury instructions. And I'm going to take a break after their arguments because I need to make a few copies for the lawyers to read while I read. We give the instructions to you in writing, but I always like it when they can read over my shoulder because sometimes I put two words in different order and it changes the meaning. So then we have like three people reading to make sure it comes out to you right. So we'll hear their closing arguments, take a short break, you'll get the instructions, and then we'll turn you loose. Go ahead, Mr. Klingler.
Your Honor, if I may, procedurally, I'd like to renew my motion for the record.
Thank you. Very appropriate. With regard to the false light claims, the court overrules the motion. Outside the presence of the jury, I can give you a little bit more of the why. But when I give deference to the evidence and construe it in favor, especially with regard to highly offensive and reasonable juror, reasonable public perception, like those clearly become fact issues to weigh, which I shouldn't do. So as a matter of law, I couldn't dismiss the claims. There's at least enough evidence when I construe the plaintiff's evidence in their favor to get past the Rule 50 motion. But you are spot on to remind me to do that.
Your Honor, there's also another matter we need to clean up. We probably should do at the sidebar before we go into oral arguments.
Okay. I like cleaning things up. a vote of 3-0, the lawyers all being unanimous, they want to see like this last draft of instructions, because often they use the instructions in their argument. So like the chicken scratching stuff that we've been doing in the past is distracting. So we're gonna let me do my work. It's 30 minutes that we need. So we'll go take a coffee break, just stay back there. Instead of me doing it the other way, we'll just take the break now for the jury instructions.
Can't smoke, can we smoke?
The bailiff doesn't like irritable jurors, so you should go smoke. Do you like irritable jurors?
I prefer not to have them.
Okay, I thought, yeah, go take a break.
All right. Thank you.
You're pretty high maintenance for the bailiff.
I figured we'll just like, exactly, yeah, like you're supposed to.
Everything you need to know is right here. Just that, yeah, correct.
I'm here for it. Woke up on the right side of the bed this morning, Judge. I'm down for anything.
It's at the right side of the ground.
This morning, she and I got pretty early sleep.
Christopher, how you doing, buddy? Excellent, Mike.
I can't disagree with that.
Jeans is
I
in
just
the
get up
uniform.
that early, so I know he's not voting, I'm like. It seems to make everybody happy, right?
There is that. I mean, you got me on that one.
What's up, jerks? Court's on shirt break. I figured I'd pop up here. How's everyone feeling today? Look at my hair. My hair's a little funky this morning. God damn, I thought this was starting at 9:30. I get the times wrong every time this week. Little I hit the wrong stream. I've had an eventful morning. Had quite the eventful morning. Just trying to cover Afroman. I didn't get high. That's the problem. I didn't get a chance to get high before streaming this morning. So I'm a little discombobulated. I need my medicine. I need I need the superpower. I see we got a guy named Afroman's neighbor here, which is funny in the chat. But we're just waiting for I guess the final statements. I thought we were gonna have a big defense from Afroman. He had one witness. I don't know what she even said. That was so quick. Did we even get anything? Like what was her the point of bringing her up? I didn't even get that point. I'd have to rewind it. Um, Not much of a defense though. I don't know. I want Afroman to win this. I do. I do at this point because I feel like these cops. There's something shady about them. But I think he might have gone over the line. He could be in some trouble. This is going to be interesting to see what the jury decides. I don't know what I would vote on this. I don't know. I'd probably say not guilty just because free speech. But geez, what do you think of the chat? Do you think right now, at this point, haven't seen all the witnesses? Do you think Afroman is not guilty of defamation or he is guilty? What's the chat think out there? What do you think? What's your feelings? I want to know. Cuz I don't know. This is going to be a tough one for the jury, I think. But we're just waiting. I guess we're going to wait to see. They're going to give jury instructions. They're going to give their final closing statements. And then I guess that's it. It's going to go to the jury. I was hoping this would go the full day today. I was wanting to see a full day, but it looks like it's going to be a short day. At 10:30, Kelsey Fitzsimmons is going to be back in court today. We'll be covering that. Not guilty. They just butthurt, says Cafe. So 10:30 we'll be covering on a separate stream the Kelsey Fitzsimmons 10:30 hearing today. And maybe I might even cover that other antifreeze murder trial up in it's in Essex Superior Court, but it's a Salisbury murder. I don't know if people have heard about this one, but we might cover that today. Who knows? Looks like we may have some time. But I see everyone saying not guilty. Everyone in the chat so far is not guilty. Yeah, I am definitely getting old. Today I felt it. I was up too late last night watching JFK. Fell asleep watching JFK again last night. I got a busy day tonight too as well. 7 p.m. We're gonna have retired Judge Carol Erskine here talking about Kelsey Fitzsimmons as well. 7 p.m. So we got a big day today. A lot happening on the Young Jerks. I want to thank all the new subscribers or the people who were resubscribed. I've heard a lot of that lately. I heard a lot from people that said they never unsubscribed. YouTube did it to them, and they just discovered it, and they're back. Thank God. Thank you for being back. Make sure you are subscribed. Hit that subscribe button. All notifications. Does anybody remember Two Live Crew? Uncle Luke, you mean? Luke? Of course we do. I mean, I'm old. Of course I remember Two Live Crew. They got in a lot of trouble. Those were bad boys. They were fun though, weren't they? Don't listen to Two Live Crew around your young children. That's my only advice. Yeah, seeing a lot of not guilties here. I haven't seen one person think he's guilty here in the chat. Everyone's been not guilty today. What do you think? Afroman guilty or not guilty of defamation? Yeah, I'm wondering. The thing is, I remember Two Live Crew did get sued, but I don't remember were they found not guilty. Now I'm going to look it up. Was Two Live Crew Let's look this up. I remember them getting sued, but I can't remember what it was about. All I'm seeing is about them suing the record label right now. Ah, here it is. Campbell versus A Cuff Rose Music Incorporated. Glad you brought that up. Let's take a look at this. Yeah, Tippa Gore tried to cancel him. I remember that. Tippa Gore tried to cancel everyone. She tried to cancel John Denver. Remember that? John Denver came out. Rocky Mountain High. Twisted Sister, we're not going to take it. I love Dee Snider. I once met Dee Snider in an airport coming back from Jamaica. He ran away from us. He didn't want to talk to us. We were like, I want to rock. He looked at us. He's like, I don't want to talk to you. I still like him, even though he didn't want to talk to us. I don't blame him. We're a bunch of drunk college kids. This looks like it was, yeah, copyright infringement. I don't know if this is really quite the same thing. Maybe I'm missing something. 1990, not guilty. Yes. I'm gonna stop the screen because I want to make sure we're not missing court. We're not missing anything in court, right? Nothing's going on in court yet. We're waiting. We're waiting. We're hanging out. We had a great show last night too with Nan Gallagher. Attorney Nan Gallagher last night was phenomenal. Really good show. Good audience. Good questions. I want to thank our mods. I want to thank Nan Gallagher for being here. I haven't had my breakfast yet. Haven't had my breakfast. I need some breakfast. I wish they would come back live so I could have some breakfast. I got to clean the house today too. We got the house cleaners coming, so I got to clean the house for the cleaners to clean. I don't know how we ended up doing this, but this is what we do every couple of weeks here. We clean the house so the cleaners can come in and clean. That's what I'm going to be doing this morning. And walking some dogs. I got some dogs to walk today. But yeah, we're just waiting for these final statements from the defense and the prosecution in this Afroman trial. And it looks like it's going to end today. It looks like the jury's going to have this in their hands later today. I bet we have a verdict by the weekend, probably by tomorrow. We'll see. But we're just chilling, waiting to see what happens here. You enjoyed Nan last night. I did too. Great to have Nan back on the show. It was funny too because I posted it up in the Kelsey Fitzsimmons page, the Facebook group that Nan was going to be on the show. You'd think that I stabbed somebody. It's unbelievable. It's unbelievable to be there from the beginning of the start of the Kelsey Fitzsimmons thing and then have people act like you weren't there. All these new people. It's just like all these new complainers, crybabies, bunch of crybabies. It's funny how they pretend that I'm a whiner, that I'm a crybaby. I'm living life. I'm living damn good. All they do, and it's funny every time they say that too. These crybaby whiners that I see, when I go look at their social media, all I see is a bunch of crying. Like it's the projection is off the chart. There's Nick Rocco. See, I'm not crying. I got Nick Rocco in the chat. Nick Rocco knows about the crybabies. It's funny. Like I've never had any issues with any ex-girlfriends. That should. I've never sued anyone. I've never had a harassment prevention order that I've filed against anyone or filed against me. Obviously, I don't cry that much. Unlike some other people. It's funny about these projection artists, the ones that want to push it on me, but they're the ones. If you look in their cupboards, you're gonna find a bunch of skeletons because that's what they always are. It's the projection is off the chart. Nick Rocco says, "I can't believe what they're doing to Afroman. What a weak defamation suit." See, Nick, I'm not sure. I think Afroman's got some good points. I think he was very valid to criticize these cops. He may have stepped over the line though when he called that guy a pedo. Like that's the issue I think that the jury's going to have, and that's the reason I'm not sure he's going to win this. There's a good chance he does win because it's a jury and the jury gets what's going on, why he's mad. He's got a reason to be mad. They raided his house for bullshit. You know what I'm saying? So like he probably will win, but because he called the guy a pedo, that's what I think is wrong here. I think it's really like, it's going to be a tough one for him. We'll see. That's why I'm not 100% sure he's going to win this one. Yeah, the pedo is a tough one. Because if you call someone a pedo, you really have to have that backed up. Yeah, I know, right? That's the thing. You'll never catch me crying on camera. You'll never catch me like real crying, like tears and all that shit. I was thinking about the last time I cried. I think the last time, like legitimately, I cried is when the Patriots lost to the Chicago Bears. Remember that? With the fridge. I think that was the last time I legitimately cried. Like, because I can remember thinking like my great grandmother died and I didn't cry and I'm crying about the Patriots. I was a kid. I was like, grow up, dude. What are you crying about a fucking sports game? Trying to think if I cried even when my best friend died, Michael, which, Michael Malta. Maybe. I probably had a couple tears. I'm not a crybaby. I don't know. I don't know what these people are thinking. It's funny when they want to put something on you and it's not you at all. It's like they don't know me. They just don't know me. They haven't met me. Court rescheduled for who? Are you talking about Kelsey or Afroman? As far as I know, they're all on. They're all on as far as I know. 10:30 today for Kelsey Fitzsimmons. And right now we're waiting for the court. They're gonna give their final statements in this defamation trial. And then the judge is gonna read the jury instructions, and the jury's gonna have it later today. Yeah, they do. That's the thing. They project and confess. That's the thing about snitches now. I don't know. I grew up in the 80s and 90s where you weren't a whiny, snivelly little snitch. Like snitching was not cool. Now snitching has become such a big thing that people don't only just snitch on other people, they snitch on themselves. That's what happens a lot now, I notice. The like look at this guy where there was a body found in a house buried in the garage. The guy snitched. This was I think up in Tewksbury, something like that. Tingsboro. Did you see this one? The guy fucking snitched on himself. He told somebody. That's how they found the body. That's how they discovered. That's how they were like, "Whoa, we got to go look in this garage." They look in the garage and there's like new concrete poured, and they're like, "Oh, that must be where the body is." They dug it up and they found a body, and the guy self snitched. I just can't get over it. Today is like the criminals. I mean, that's the thing. We're looking at, I always say this about Trump and all that. Like, he's the same way. Self confessions, like they snitch on themselves. That's a new thing. They do the crime out in the open, and then they tell you what they're doing. It's like Epstein. Epstein was basically self-snitching the whole time. No one. It's the new way. It's unbelievable. People will self-snitch not only on their best friend or their mother or their brother. They literally self-snitch on themselves now. There's a lot of that going on. Yeah, Tingsboro. You know where I'm talking about. Yeah, this is the whole thing about Afroman. The cops got a warrant to search Afroman's house based on accusations of kidnapping, among other things. All were unfounded. All Afroman wanted back was his money and his door, and they found nothing. They found like 2 joints, and medical cannabis was already legal at that point in Ohio. So there's no way they had no charges. He got charged with nothing. That's the bottom line. This is a bogus raid, bogus warrant, no charges. Yeah, the the criminals are much dumber than before. Something happened in the 80s because before that, you didn't talk. Like I remember at one point I was, went to Bridgewater State. There was a lot of kids from Southie that I'd go to school with or even hang out with. And you'd ask like, "Hey, do you know Whitey Bulger?" And just asking that question, they'd want to fight you. They'd literally be like, you're snitching." Boom. Like they'd want to fight. You just ask the question about it. Like things have changed. Now people are like, "Yeah, I know Whitey. Let me tell you all the secrets." Like people snitch on everything now. Not only that, if they know Whitey, they got a YouTube show that they're gonna snitch about it on. And we're still waiting to see what goes on in court here. Nothing happening. I'm watching the court feed. Nothing is happening. That I think this is the problem. People don't get the stitches anymore. This is the problem. It's been so frustrating for me because I grew up in an age where we just fight it out. We get in a fist fight. Like, let's just settle it. Let's settle it. Yeah, the music was good back then too. It really was. Where's Whitey? That's the thing about today. The culture is so different. These kids, they don't want to know anything. It seems like they just want to sit at home. I hate to be that old man. I'm an old man now. Look at me, yelling at clouds. Get off my lawn, kid. Oh, murder is still observed by some, not many. It's definitely a dying culture, dying breed. I mean, you even have ex-mafia guys that have true crime podcasts and they tell all the stories now. Sammy the Bull, Michael Franceschi, whatever his name is there. I think the only place the code of silence still happens is with the police. They're the only ones that try not to snitch. I did Whitey actually call in? Was that a real Whitey call in? WBCN in the 90s? I must have missed that. I was probably at Bridgewater State College. It sucked. One of the things that sucked about going to Bridgewater is it was hard to get WBCN in, and even the local Boston TV stations. We always had an issue. We'd have the old antenna, and the reception sucked down there. We'd get a couple Rhode Island channels, so I missed a lot of the early '90s on BCN. Unfortunately, yeah, it was the listeners calling in, of course. I used to do a lot of different jobs. Let's just put it that way. One of the jobs I had at one point was going to recover and pick up cable boxes. You remember you'd have I was like a cable box repo man for a few weeks during the summer. One period of time, and I was in South Boston, and I thought I saw Whitey Bulger on the run. This guy like gave me some directions, and I'm like, was that Whitey? I think I might have seen him on the run. I think he gave me directions in Southie in the early '90s. I swear to God, I was shitting myself when I thought about it after. I was like, was that Whitey Bulger that just gave me directions? It might have been. He was on the run. And now we find out all kinds of new stuff's coming out. You know who's been covering Howie Carr? Howie Carr. Howie Carr has been just getting it on about Whitey right now. I always piss people off. I'm just like that. I'm a stubborn Irishman. I just don't give a shit. You no cable for you. We didn't have cable at Bridgewater State College. No cable. I bet they all have cable now. I bet they got internet modems in every room. Things have changed. They don't have the rabbit ears. That's one of the reasons why I watch Fast Times at Ridgemont High so much. We had the VCR. We had one videotape. It was Fast Times at Ridgemont High. We must have watched that like 1,000 times. And back then, you'd have Channel 10 in Providence. That was about it. That would come in well. And like at 1 a.m., it's all infomercials. So we just throw in Fast Times at Ridgemont High again. Hit play. No cable. Yeah, I should have called. I should have called it in on Whitey. No, I'm glad I didn't. Like I said, I came from a culture no snitching. I didn't tell anybody. I kept my mouth shut until now. What do I think about this case? Like I said, I think that the thing is, I think that Afroman could win this because these guys did raid his house and it was a bunch of bullshit and it looks like there was money missing and there were some issues with them and their past. But at the same time, did he go too far? There's a fine line. When he called that officer a pedo, I think that could be the issue for him. If he loses this, I have a feeling it's going to be about that. So we'll see. Like, I don't know. I don't know what kind of jury he has, how they're feeling. I don't know the racial composition because I think that will come into play. I think if it's all white men, he's screwed. If there's some black people on that jury, I think he's got a very good chance. I do. And I think race comes into play because this is probably a lot of his anger is the racial profile aspect. And in the profiling of, oh, he's a marijuana hip hop star. Let's go raid his house. He must be up to no good. So I really think it depends on who's on that jury. We'll see what happens. I think this could go either way, honestly. I was kind of hoping and expecting that he would have a little better of a defense, more witnesses. He had like one witness this morning. I don't even know what she said. By the time I started listening, it was over. So did she add anything? I don't know what she added. I was kind of flustered this morning. I thought it was started at 9:30 Eastern time. It started at like 8:30. So I kind of missed it. And now we're waiting, which is weird because they said, "Oh, we're gonna go to closing statements. Oh, let's take a break." I don't get what's going on right now. I don't. I wish they would have told us, like, we're gonna take a half-hour break, a 1-hour break. What is going on right here? Like, am I gonna sit here all morning waiting for them to come back? I don't know. Well, this is the funny thing, Sheila. I used to have this New Jersey state cop that used to be Jack Cole, who wanted to legalize drugs, and he was like a big time drug cop, and he would go undercover and bust gangs and drug dealers. And at one point, he said, the reason why law enforcement likes to bust the potheads is because they're not violent. They show up for court. They pay their fines. They just want it to be over. They usually take a plea deal. They make it easy for us. Would you rather deal with easy criminals, easy supposed criminals, or would you rather, deal with hardened, violent criminals who don't show up? That's why a lot of times they did like to bust the pot dealers. And it's one of the reasons why he became anti-drug war is he said some of these people I busted, especially for the weed, I actually liked them. I thought they were good people. I felt bad after I ruined their lives by busting them. That's one of the reasons why he wanted to legalize. But it's funny, I think that's one of the reasons some of these sadistic cops like to target cannabis people because they're not gonna attack you. They're not gonna rip your eyes out. Right? Cannabis people aren't on meth. Yeah. They're not like the people on meth. They show up and they pay their fines. That's the other thing they like. They pay their fines. They don't have to go search for them later. Ah, okay. So this is what that woman testified for. She was basically confirming that her kids laughed and thought it was funny about the video. He confirmed getting restraining order for her violent acts. Oh wow. So I guess that was a good witness for him. Yeah, us weed smokers are chill. We don't resist. I know when I got arrested for weed one time, I basically just tried to talk the cop out of it and just kind of shame him. I had like a stack of stain tickets in my car when I got busted by the state police because I had been, basically I had a deal with Budweiser. They were one of my sponsors, and they had sponsored this concert with Stained, and they gave me like a stack of free Stained tickets at in Boston, like probably 1,000 of them, where they were going to perform a show for Budweiser. And so when I got pulled over by the state police, I was like, he opens my trunk and he's like, "What are all these tickets? Are you a ticket scalper?" I'm like, "No, dude, they're free. You want some? Take some tickets. You can have them. I'm giving them away. Take a couple tickets." And he's like, "Are you trying to bribe me?" Like he got all mad. And I'm like, "Dude, I'm just trying to show you that us weed heads aren't bad people. Like, just calm the fuck down, bro. You ruined my life. Take some fucking stain tickets." But I gotta say, like, I'm rooting for Afroman. I am. I want to see him win. I mean, I think everybody does. Whether you think he's gonna be found guilty or not on this, I want him to win. I do. I was gonna go to court, then I got high. That's the only thing I don't like about the Afroman song, because it's like, for me, I'm like, you know, in college, I think I said this recently. One of my roommates, he's like an anti-cannabis guy. I think he's a football coach now. And he never like was never into weed or anything. He used to make fun of us. And then one night I got like I lived with like five dudes and our kitchen was a mess. Like literally the sink, right? Like there was like a freaking like that many dishes in the sink. Like it was like way over. It was just like we had mice in there. It was fucking awful. And one night I got baked, and I'm like, I'm cleaning that fucking kitchen. I don't care if I have to take a baseball bat to all the mice in there. I'm cleaning. And so I got high, and I cleaned up every dish. I cleaned up the whole kitchen. And he's like, craw, craw. He's like, I think I'm pro weed now. I'm like, why? He's like, you get baked, and then you go fucking clean the kitchen that no one would touch, no one would clean. I'm like, I'm like unusual. Like most people assume you get stoned and then you get lazy. I get stoned and I want to like edit videos. I want to go walk dogs. I want to like go wash the car. I want to go clean the house. It's like that's the opposite to me. He became pro cannabis. He doesn't smoke cannabis, but he became pro cannabis. Yeah, clean. There are some of us out there. We'd like to clean high when we're high. I mean, all the landscapers I ever worked with too. Like I used to work in some golf courses a little bit. That was another job I did, mowing lawns. Every landscaper, just about on the golf course, be friggin' Did that little one hitter off to the side, taking a puff, and then putting their glasses on, and let's go mow some lawns now. So we can be productive. Like, the Afro Man song kind of played into the stereotype that s- I got stoned and now I'm lazy, which it does do that to some people. It definitely does. I've seen that. But there's other of us, there's others, there's the other end of it where some of us like to get high and get shit done. That's me. And I've always been like, if my whole life, I was like, if I work really hard and make good money, then I can afford to get, can afford to end my day with a nice fat joint. It's like kind of a reward too. I think it's all how you look at it. Ah. So we're talking about cannabis because Afro Man, right? If he wins, they should play the song. Imagine that. If he wins, they should just all of a sudden just press the button and play the pound cake song. And then he does a concert, and they should have him close. They should have him do a concert to close out this trial. Yeah, painters of those guys smoke a lot of weed too. Anybody that's in the construction field, a lot of them like to smoke the weed, especially the landscapers. You ever notice that? Especially the guys on the golf courses. Yeah, he's gonna have some more hits if he wins. Can you imagine what songs he's gonna put out next if he wins this case? Those cops are gonna have to move to Jamaica or something. They're gonna have to just. Oh, this is the funniest thing too. Like, we're all getting copyright striked. Everyone who played that in court was getting. It wasn't the. There's different levels of copyright strikes on YouTube, especially with songs. Now it seems like they're much cooler, but you can still get in some trouble. But most of the artists today are just saying, "Put my ads on your video and you can play my song." And that's what happened with the Afro Man Pound Cake. Like, everybody that played the court hearing, we're all paying Afro Man. We're all paying him the ad money. He's getting money. He's getting rich off of this court case. Is basically what I'm saying. Is he's getting all the streaming money. Afro Man is getting all that streaming money because they played Pound Cake on in court. It's fucking hilarious. I mean, he's got it hooked up on Facebook and YouTube. Every single one of my fucking social medias was like, "This song is copyrighted by Afro Man. He's gonna take all the ad money. He's getting rich. He's getting rich off of court. I love it." Yeah, Ruthie gets it. I think that's Afro Man too. He got high and he wrote all those songs. Yeah, no, I didn't get struck. Basically, a lot of the musicians, a lot of the songwriters, they'll copyright their songs and they'll just basically say, if someone uses my song, put my ads in there, so they get paid. He's gonna do a free show. If maybe I should go to that. Maybe I should. Where is this free show gonna be? Maybe I need to book my tickets. Maybe I need to go. Still nothing going on in court. I said short break, but it's been a long break now. The hell is going on in court? See, I wish I knew how long it was, because there's another interview that Afro Man did recently that I want to play on the channel, but I don't want to start it and have to stop it if court comes back. I wish we knew how long this was going to last. God damn. Good morning, Sheila. Good morning, Sheila. I think all of our mods here. I want to thank everyone who's sitting with us waiting. I know I'm trying. I'm trying. I hit up his agent yesterday. I never heard back. Never heard back. He said, he basically said he was down. He said, sent me a text, and then I never heard back on text. Yeah, I'm just checking to see. Nothing back from Afroman's manager, unfortunately. Yeah, I might have to smoke some weed for that one if Afroman comes on. That will be. I'll have to bring out my jaw. Like, Afroman, you want some? Come see me. I grew this. I grew this Afroman. I never smoked it, but I grew it. It's my specimen. I would love to get Afroman. If you know him, put a word in for us. Hit him up on Twitter and say you got to do the Young Jerks, bro. Let him know. I need to go get high. God damn. God damn, I need to get high. I also have to do some dog walks, so I can't get high right now. I try to be good until work's done. Yeah, hook us up. We're still waiting for court. Nothing going on in court right now. Goddamn, I'm almost wondering if I shouldn't watch the other court case going on with this antifreeze murder. It looks like nothing's going on over there either right now. A couple hits won't kill me. Definitely won't kill me. Oh, is that where he's doing the concert? He's gonna do Winchester, Ohio? Is that where the free concert's gonna be happening? Still nothing going on in court. We're waiting. And again, at 10:30, we're gonna be streaming the Kelsey Fitzsimmons court hearing as well. The court came back from another break and started another break. I know they've been in break all morning. It's frustrating. Oh, something maybe going on. No, that's the other court case. I'm watching multiple cases here at once. Sorry.
Law where necessary and put them in. And you didn't deal with that, but sometimes I have to tell the jury how we got to where we are. That becomes instructional law. The law of the case goes into the instructions. So, and I don't explain it to them. I'm just saying to the record, I took prior judicial law of the case findings and slotted it in where necessary, because that's what we always do. Sound right, Mr. Osborne?
Your Honor, I had no objection.
No objection, Judge.
Okay.
Yes.
Off the record, you want to start?
I would love Your Honor.
Yes, sir. We're off the record.
Well, we have the two housekeeping things. I have to renew my verdict, and then we have to also discuss the music company.
Okay. Back on the record.
We're back on the record.
Okay, so 2 points came up. You wanted to renew your motion for Rule 50
Yes.
dismissal, which the court will overrule. Mr. Klingler responded to your inquiry about the Access Incorporated.
Yes, Your Honor, just for the sake of the record, we had a telephone conference on this, we had discussed this issue. They had not pled, they are technically in default of the answer. During that telephone conference, which was not on the record, we discussed what would happen with that. Mr. Klingler said he would evaluate it. We are now about ready to do closing statements. No evidence has been presented against him. Mr. Klingler has not asked for a default judgment. He seems to be wanting to put everything on my client, which is very strange why when he has a default, he wants to make a motion for such. But we would ask that the record be cleaned up in that issue.
Yeah, I'm going to clean up the record, and we are willing to dismiss that party from the case.
The Access Incorporated.
Yes.
Your Honor, we've registered an objection to him not doing a directed verdict, doing a default verdict on that, and therefore increasing damages upon my client if they should be found.
I don't think he gets to own his own complaint, so I just have to follow his lead. But I get what you're saying, and
I can argue for mitigation of attorney fees and stuff that he has done.
No, if it gets to that, if it gets to that, that's not a part of the jury's deliberation.
I'm trying to think a step ahead.
I'd like that. Off the record, please. Go ahead and you with Mr. Bailiff.
Time to go. See, I knew that. I waited the extra 30 seconds.
You got 6 minutes for it.
Absolutely.
Okay, thank you, ladies and gentlemen, for your patience. Have a seat. That actually was about 45 minutes, so I didn't gauge my time very well, but thank you for your patience. We are moving ahead, as you know, so most people don't growl about that, but I try to at least respect your time and tell you what we're doing. We made it through, like, the corrections to the jury instructions. Like I've been trying to educate you all the way through. The jury instructions are the textbook at the end. So the lawyers had a chance to drill those down. As I said before, closing arguments are the attorney's argument about what they think the evidence means and how you should do whatever it is they think you should do. So they go first, Mr. Klingler, then Mr. Osborne, then Mr. Klingler. There's like a total of 35 minutes. So I'm going to think 20, 35, 15. But Mr. Klingler can kind of manipulate his time depending on how he wants to do it. So in an hour, you'll be talking to me for about 30 minutes of instructions before you start your deliberations. That's what's ahead of you. If you take notes, just write down argument, not evidence. Go ahead, Mr. Klingler.
Thank you, Your Honor. Morning, folks. When this trial started, I told you it was about intentional lies that are designed to hurt people. It's not about freedom of speech. It's about defamation. It's about false light defamation, intentional lies designed to hurt people. You've heard all the evidence. You've seen the witnesses. I'm not going to go over it. But I will say a few things to underscore what I think is most important for you to keep in mind as this case is turned over to you, from me, from the plaintiffs, to you. Mr. Foreman perpetuated lies intentionally, repeatedly, over 3.5 years on the internet about these 7 brave deputy sheriffs who've lived in this county for years, risked their lives for this county for years, done their job, been in the community for many, many years. Mr. Foreman did it intentionally. Mr. Foreman knew that what he posted on the internet were lies. He knew there was no theft. He knew there was no sex with Randy Walters' wife. And he certainly knew all of the stuff he's repeatedly posted about Lisa Phillips up until Friday and probably later were lies too. What are we going to do about that? Mr. Foreman told you from the witness stand, there's nothing we can do to stop him because he has freedom of speech to lie about people intentionally. During jury selection, we talked about that. And you all agreed that it's not okay to tell an intentional lie about someone that hurts them. We all agreed. And the judge is going to tell you that in the law that he gives you. So Mr. Foreman is legally wrong when he says he has free speech to tell harmful lies about people and get away with it. That's just legally wrong. You also told me in jury selection that even if somebody does something to you that hurts you, that you think is wrong, like a search warrant execution that you think was unfair, even if somebody does that to you, you told me, we all agreed, that that doesn't justify telling intentional lies designed to hurt people. That's what you think. That's what the community thinks. That's what decent people think. But Mr. Foreman thinks it's okay to do what he's done over 3.5 years because they executed a search warrant that broke down his door and disconnected his cameras. You heard from the witness stand, from Mr. Foreman, the callous indifference that he showed to what he's done, the harm he's done. It's imprinted in your minds, I'm sure, like it is in mine, the tears, the agony from some of these witnesses. Don't forget that when you're back in the jury room. That's what this case is about. You are here because you agreed to be here. You showed up on the first day. Not everybody does. A lot of people don't respond to their summons. You did. I asked you, do you want to be on this jury? And you all said, yes, I agreed to be on this jury. You're all here now in this place, in this courtroom, for a reason. And I believe there's a power higher than us that brought you here today to do this job, and that you are the chosen people to do it. Nobody else is going to do it. There's not going to be another trial. There's not going to be a second chance. This is the day to decide whether Mr. Foreman gets away with what he's done and whether these plaintiffs deserve something to make up for what they've been through, and whether the community is told that what he did is unacceptable. It's not okay. We talked about different kinds of damages. There's not going to be economic damages in this case. There's no doctor bills. There's no damaged property. There's damage to reputation. There's pain and suffering. There's public humiliation. There's everything you saw and heard from these detectives from the witness stand. And the only thing you can do as a jury to decide this case is to render a verdict of money that somehow stands in, somehow represents the harm that these deputy sheriffs have been put through over 3.5 years. That's all you can do. You can't issue an order that says stop. You can't issue an order that says, say you're sorry. All you can do is issue a verdict for an amount that fairly stands in, represents what they've been through, what they've lost. No one else is going to do it. The judge isn't going to do it. Court of Appeals isn't going to do it. It's your job. And you're the people meant to do it. Now, I told you in jury selection, if we got to this point, I'd try to give you some ideas about how to evaluate what kind of verdict might make sense in this case. I told you then, and I'll tell you now, there's no formula. There's no easy answer. But there is an answer. And it's the answer that you folks decide among yourselves fairly represents the injuries that these deputies have suffered. And I'll start by posing this question. Do you think that if there had been an advertisement in some newspaper that said, we will give you $2 million if you are willing to go through what Lisa Phillips has been through for the last 3.5 years? Would you take that deal? Do you think she would have taken that deal? Yeah, $2 million, that's a, maybe I'll go through that. Of course not. Do you think Randy Walters, do you think Brian Newland, do you think any of these deputies would have accepted some amount of money in order to go through, in exchange for going through what they've been through? I don't think so. And I think you know nothing is worth going through what they've been through. And, of course, he says he's not going to stop. He says nothing can stop him. Maybe something can stop him if you tell him through your verdict that he needs to stop. I'm going to tell you what I believe is a fair verdict for these plaintiffs. And it's up to you, of course, again, to make the decision. But I would ask you, I'm going to ask you, and there's a verdict form which, excuse me 1 minute. Folks, I'm going to show you these forms that you're going to be filling out, just so you're familiar with them. This is just an example. You're going to have a different form for each of these plaintiffs, okay? This one happens to be a verdict form for Lisa Phillips. And I believe the evidence is overwhelming that you'll find in favor of Lisa Phillips. This happens to be her false light claim. There's a separate claim for defamation, a separate form for defamation, and you'll see the jury instructions. Judge Hine has already talked some about that with you. So this is just an example of the verdict form that I'm going to ask you all to sign in favor of Lisa Phillips and all of the plaintiffs on their false light and their defamation claims. Now, there's another form called an interrogatory, and I'm just showing you Lisa Phillips's form. And it says, we, the jury, find damages for plaintiff as follows. And then it gives a little description of the kind of damages. And there's a line for your decision, and there's signature lines for each of you to sign. For Lisa Phillips, I'm not going to show you every form. For Lisa Phillips, folks, I'm asking you to put $1.5 million in that verdict form. $1.5 million for Lisa Phillips from what she's been through for 3.5 years. Maybe going through for who knows how long. For Brian Newland, I'm asking you to issue a verdict for $1 million for what he's been through with his family, the loss of his dream job here in Adams County. For Randy Walters, I'm asking you for a verdict of $1 million for what he's been through with the allegations and vile videos about his wife. For the other 4 plaintiffs, Sean Grooms, Sean Cooley, Justin Cooley, and Mike Estep, I'm asking you for a total, for all 4 of them, of $400,000 divided among them however you see fit based on their testimony. You, of course, can award less. You can issue a verdict for more. That's what I'm asking you to say in your verdict form based on this testimony. Now, let me close my remarks by looking into the future here and looking at the future if there's a verdict for the plaintiffs and you award the plaintiffs a fair amount of money. What happens? The plaintiffs are vindicated. The court of public opinion out there, the press, which I know you haven't been looking at, they don't know the facts. You know the facts. And a verdict for the plaintiff will say they were wronged, he was wrong. A verdict for the plaintiffs will make up in some way for what they've been through. A verdict for the plaintiffs will say that we don't condone, we don't approve, you can't get away with what Mr. Foreman's done. Not in this community, not in this country. That's not freedom of speech where we live. That's what a verdict for the plaintiffs will say. Let's look at another possible future if there were to be a verdict for the defendant, or if there were to be a verdict with a small amount of money attached to it. In that case, in that world, in that future, the world is told what he did is okay. What they went through is no big deal. We don't really care. We think it's fine. That's what a verdict for the defendant or a small verdict would say. They would go home subject to even more ridicule. Yeah, you took him on and you lost. See, what he did was fine. I don't have to tell you, you know, that's not the message we want to send. It's not the message you want to send. Folks, I'm done. I've done all I can. These folks called me 3 years ago now and asked, what can we do to stop this? And here we are today. I've done what I can. They've done what they can. They've suffered through the publicity. They could have stopped this case at any time if they would have kowtowed to the pressure, public humiliation that Mr. Foreman continued to put them through, but they didn't. They bravely stood behind their case and their right not to be dragged through the mud with lies in the media. They've done all they can. And now I am giving their case and this decision to you. It's out of my hands. You have to decide what to say to Mr. Foreman and what to say to the community about what he's done and the effects that it's had on these folks. I have full confidence, I fully trust you to make the right decision, to make a fair decision, and to come back with a verdict that's fair for each one of these plaintiffs and that tells the community what you really think about this case. Thank you very much.
Thank you, Mr. Clementer. You have 11 minutes after that. Final. And Mr. Osborne?
Ladies and gentlemen, thank you for being here. This has been a long 3 days. It took a second for me to even count the number. It's been so long. A lot's happened. You've done your duty as jurors. You've paid attention to the evidence. I'm proud of that. What makes our country great is you have the right to have a jury trial. You have the right to people in the community to see this, weigh the evidence, and make a decision. And I'm proud that you guys are here and doing that. We started this time, I talked about this case was about freedom of speech. But let's talk about what it's also about. It's also about music. Not all music is tasteful. Not everybody likes all music. There's some songs I hate. I think we can find plenty of people that find songs they do not like. But Mr. Foreman, Joe is a rapper and comedian. It's what he's done his whole life is rap, make songs. We got to think of what rap is, because music does not exist in a vacuum. Music evolves over time. Take a look at jazz. It's evolved. At one time, it was distinct in a certain subculture, and it has now expanded. Rap is the same. Rap started out as a means for people to express social commentary, opinions through entertainment. Look at the song by NWA. What do they call it? Fuck the Police? I think I said that right. It's a social commentary on what was going on in their lives. Their personal effect, the personal things happening to them, combined with entertainment, which unfortunately is exaggeration. Opinion, nothing of fact in that song. It's a commentary on society. And so when you look at rap, you see that over and over again. I had my secretary print me a couple songs, rap songs, while I was pouring a cup of coffee. And the first one's Carly B, WAP. I find it bad to say what WAP means, but it's a popular song. I think it's somewhat derogatory. But then again, I'm not the audience for that song, and I know that. I know nothing in that song. Nothing talking about is true. I know it's not. I know it's entertainment. I know it's social commentary. Miss Grooms testified even her students knew that at a young age. The same thing I knew when I was watching Johnny Carson, The Late Night Show, and SNL, Saturday Night Live, with my grandfather when I was a kid. That's all entertainment. They make fun of everybody for entertainment. And some of it is a social commentary. But it is not fact. And everybody knows that. Nobody looks at Lil Wayne's song Pussy Monster and says there's a monster in that song. Everybody knows it's exaggeration for entertainment. Is he commenting on something? Sure. But it's not fact. And I can keep going. Megan Thee Stallion with sex talk. I mean, it just goes on. They use derogatory language. It's designed to entertain. Drew Hastings, former mayor of Hillsborough, was a comedian. I got to go to one of his stand-ups. Some of it was funny, some of it wasn't. Some of his jokes, like those of Eddie Murphy and Richard Pryor, some of them are not tasteful, but they're still jokes. They're not facts. And we know that. That's what a reasonable person listening to that would understand. And that's the point. This is not a vacuum. We don't live in a vacuum. Let's face it, if we lived in a vacuum, we'd all be dead because we couldn't breathe. So we live in a world full of everything, where we see things. We watch SNL. We know it's entertainment. We know it's going to pick on people. We understand that they're picking on public officials. Hell, they picked on Joe. They pick on Donald Trump all the time, Sleepy Joe. I mean, go down the list, even Teflon Ron was made fun of. So as you go back, nobody thinks that's fact. Nobody's going to take it that way. When they post their clips on YouTube, when they post their clips on Facebook, people don't look at it and go, that's the truth. No, they understand it's comedy. They understand they're going to talk about it going forward. And if you look at his posts, you see the little signs of that too. Iteration. Things that you see in a song. I mean, because after all, you know, a song's catchy, right? It has beat, song, you know, words rhyme. You know, she thinks my tractor's sexy, and, you know, sticks with you. And we listen to Lemon Pound Cake. You heard the iteration. You heard how it came together as entertainment. So we don't exist in a vacuum, and a reasonable person doesn't exist in a vacuum. As the judge has said, you are a reasonable people. You get to decide what's reasonable, which means you get to use your experience. You get to use your understanding of what those are, of your understanding of Joe, of your understanding of rap music, music in general. I'm not going to sit here and say that these 7 people were happy about what happened to them. I'm not going to say that. That'd be stupid. But what I am going to say is they are public officials. We see it on the news all the time, public officials made fun of. Let's go back to voir dire. During my voir dire, we talked about, with the one juror that's gone, we talked about that, yes, I ran for public office. She agreed I put myself out as a public official. She agreed that it was an opinion when someone called me a baby killer. Even our witnesses on the stand, I asked that question. They said a crooked defense attorney is not a vine, it's a matter of opinion. Crooked cops, dirty defense attorneys. Oh wait, one witness did want to say I might not have taken a shower. But those are all opinions, exaggerations, not statements of fact. And we know that. And that's why public officials are held to a higher standard, because that standard is what is expected of them as subjecting themselves to public scrutiny. They all testified that people have criticized their work. I mean, after all, we look at the search. There is, even Mr. Newland admitted it wasn't perfect. I think we can see from how the money was handled, the investigation. I would have liked to have seen a more thorough job myself. I mean, we have a chain of custody, the money that just leaves it laying there. Mr. Newland didn't know that. We have an unsealed evidence bag. We have 10% of all evidence, money evidence in the Adams County evidence locker miscounted. And then, keep in mind that that miscount on those is less than what is alleged to miss here. We got people saying we had a miscount, yet they can't even bother to notify the court in an official document that they made a mistake. Just let it ride. As far as the public record knows, which they never corrected, Mr. Foreman never got back all of his money. They want to talk about an investigation, but they can't even put in a single piece of paper to correct his mistake. I don't know if I call that lazy or what. But I think it goes to what you consider a fact. Because what is a fact? We can't always know what a fact is. A fact is something you can disprove, right? But can we truly disprove that? Looking at all the evidence, there is questions. If there's questions, it's not a fact. Now, people will form opinions based on that. I formed an opinion. I imagine everybody here's formed an opinion. we know that they formed an opinion because they didn't like being called a thief. So that was their opinion. But people are allowed to have opinions. People are allowed to express them. What people are expressing when they call them thief is not a literal statement. It is not a fact. It is a social commentary on the fact that they didn't do things correctly. And they can't even articulate how they could fix it. That is a social commentary if I ever heard one. They don't like it? That's not their choice to like it or not. They're public officials. They're going to be held to a higher standard. Their work's going to be criticized. I mean, that's just what happens when you're a public official. No reasonable person would expect a police officer not to be criticized. They've all been called names before. Has it affected them personally? Yes. Ms. Grooms testified it made no difference in her life. Her kids didn't take it seriously. And she's taught for damn near 30 years. But they seem to take it seriously. And I come back to Mr. Grooms. He's worried about going out on a call and being shot. Now, maybe I'm old-fashioned. But if I'm going out on a call, I'm worried about getting shot, I'm going to call my wife and tell her to be safe. Not sit here and go, I'm worried about me. That's not what you do. You take care of your family. Mr. Walters wanted to point that out. That just goes to show us he didn't take it seriously. Now, I'm not going to say they're not afraid. Anytime they go on a call, the highway patrol will tell you scariest thing's a traffic stop. You know nothing about the person. You're there by yourself, and things can change in an instant. Is that scary? Fuck yeah. I'd be scared. But if you're truly scared, you take the steps for it. You start having your family do stuff. You start doing that. If you believe what you're saying, you take the steps towards it. You didn't take the steps. No one else talked about how they took the steps either, did they? And why does that matter? Because a reasonable person is going to look at that. After all, let's go back to me not taking a shower. How would you know I didn't take a shower? Hair clumpy, probably matted, probably got dirt all over me. That's how you would see. That's how you would prove if that's an opinion or fact. Now, even then you might say Dave just fell in the mud. But no reasonable person would take it in the vacuum. And I want you to think about everything in context. What rap is music, how it's entertainment, how the language works on it, how jokes are made. I want you to think back to that, because that colors how you see it. I love picking on Joe. He's a good sport for it. Look at that suit. Does this look like a man who thinks that everybody's going to assume that everything he's saying is fact? I mean, he's like a comedian. He exaggerates for the sake of entertainment. That's who he is. I'm not going to say it's tasteful to everyone, but some people do find it entertaining. I asked an important question about them. I said, do you believe everything in the newspaper? No. Do you believe everything you read on the internet? No. We all know that to be true. A reasonable person knows that. People can post opinions, social commentary, and hurtful things all over the internet. And it is just to be expected. That's why we are supposed to use our own filter, use our common sense, use our experiences in life. So while hurtful, it was not fact. It was music, entertainment. Stuff that no reasonable person would understand, especially not a public official, because we see it on TV all the time. We see it on the internet. You see it on Facebook. Sometimes people want to turn off Facebook because there's so much political commentary and stuff. But that's expected. Do I expect everything I read is fact? I don't even think most of it's fact. I think it's everybody's opinion, and opinions are like assholes. Everybody has one and it stinks. But that doesn't mean they can't have them. That doesn't mean they can't express them, and that doesn't mean they can't make a song about it. Truth is a defense. That's why we talked about the theft. That's why we showed all that. Because I wanted you to see how the money was handled. There's a lot of confusion around it. And for that reason, before I get to another point, I want to address something that's bouncing around my head. Bob says, what does this message send if you find for Mr. Foreman? I rephrase that question a little differently. What does this message send if we find that music and social commentary, while maybe not the most tasteful thing in the world, is silenced because a public official, while hurt by it, yes, unhappy by it, yes, pissed off, yes, emotional, yes. What opinion does that sound? I mean, if you can sue people, music artists, comedians, to shut them down, that's what we're looking at here. I'm sorry they feel the way they do. But there's a certain amount that you have to take as a public official. It's part of the duties as a job. As we talked about during voir dire, as I've talked about them being called a baby killer, there's certain things you take and you move on. It's part of the job. The plaintiffs, or I should say Bob, talks about how they wanted it to stop. Where was the certified cease and desist letter? Where was all this done? None of that was done until after they started the lawsuit. Until after they brought it to court to make it stop. That's what they wanted to. They wanted to make it stop. Yet they asked for money. The commentary on them is nebulous at best. You can see that when you look at it. We have Beetle Bailey, Gomer Pyle, Colonel King Kong Bundy. Some of these names are not as bad as others, yes, but they're all for artistic purpose. They're all for jokes. They're all for entertainment. This is not to paint them in a real light. No reasonable person would think that. It's kind of interesting because even Mr. Newland agreed that when he was called a pedophile by Mr. Foreman, yes, that is a horrible thing to call a person. But even he said it was Mr. Foreman's opinion. So he didn't believe it was a fact. If your own witness doesn't believe it's a fact, how can a reasonable person find it's a fact? Bob went to great lengths to say nothing will stop him. Shows us where we're at. We got to stop his expression. We got to stop entertainment. We got to stop exaggeration. That's what Bob's talking about. What chilling effect does that have on the world we live in? Think about it. You don't like what a commissioner does. You don't like what our prosecutor does. You don't like what any public official does, and you make a joke, and you're drugging the court. It may not have been a tasteful joke. It may have been a bad joke. It may have been the greatest joke ever. But what we're saying is if they don't like it, we're back here. What does that say to you, freedom of speech? What does that say to the world we live in? That's what this case is about. And Bob knows that. That's why he mentions it. That's why when you look at defamation and the jury instructions, you'll see that the first element of it is a statement. Portrayal of fact. Has to be portrayed as fact. No music video portrays as a fact. I don't watch Fuck Those Police and turn around and say, you know what, that's a fact. No. I say that's a song and it's entertainment and move on. Sometimes I try to figure out what the words mean, you know, what kind they're getting at, but I don't expect them to present a fact. Fourth element is the proximate cause. It's an interesting question there, because you'll get the definition of causation and proximate. And we never talked about that really during the trial, and it's going to be something that I want to discuss. They talked about getting phone calls. None of those posts, Joe never said, call them and tell them this. Mr. Cooley testified that they mailed pound cakes to the office. Joe never said send them a lemon pound cake. These are things that other people have done. Joe never directed them to do it. He didn't cause it. He made a joke. He cannot control how people take it. What they do, he's not that. All he can do is make a joke, make a song. So that's something to consider. Was he the proximate cause, or was it someone else? I want you to understand when they get to the question of malice, if you get that far, it has to be actual malice. Public officials, it's a higher standard. Why? Because we hold public officials to a high standard. Let's talk about the false light. That's their second cause of action. That says that a reasonable person would be justified in the eyes of the community, feeling seriously offended and aggrieved. I want you to go in on the eyes of the community. They want to say people's humiliating them, calling them names. The reality is a reasonable person in the eyes of the community is going to say, it's a song. It's a joke. I was flabbergasted to hear it myself, that they even thought it was a joke before they brought the lawsuit. Go to a Halloween party and bring a lemon pound cake. That, I almost have no words for that, honestly, because we're hurt, but it's a joke. Which one is it? So a reasonable person in the eyes of the community would understand it's a joke. Mr. Estep testified about the joke of the shirt. We got the pound cake joke. There's various jokes for this. This was not as negative. This has not changed their view in the eyes of the community, because your reputation, which is what they claim is hurt, your reputation is like a shirt. You eat a hot dog, you drop mustard on it, you get stains on your shirt. Nobody's reputation's clean. Everything you do affects your reputation. The way you perform your job affects your reputation. They all admitted to that on the stand, because I asked that question. They all said it does. How they counted that money affects their reputation. People can form opinions based on how they did their job and criticize them on it. That's a right we have. You have to forgive me, I have to flip through these, son. We didn't have a lot of time to prepare as things change on the fly. I think as you go back and deliberate, take a look at all the exhibits, analyze it in the context of music, entertainment, opinion, social commentary. It's not a fact. And if you look at it, you can see that. Like I said, it may not be tasteful, may not be nice, but even SNL's not nice. South Park's not nice. These things are social commentaries, jokes, entertainment, and some of them are not nice. But you don't have to like everything. You don't have to like everything said about you, and you don't have the right to tell everybody that everything said about you should be sued for, especially if you're a public official. As such, I ask you to deliver a verdict in Joe's favor on all claims. I ask that because when you look at it, no reasonable person could see it as a fact. No reasonable person could see it as even false light. The community, if they called them, if people called them, that's because the social commentary resonated with someone, resonated with what people experienced in the world. We've lived through a turbulent year, so we've all seen on the news what people are experiencing all over the country. Social commentary resonates because of that. That doesn't make him the proximate cause. That shows a deeper concern in our country that we should be addressing, not sitting here trying to decide if a music video is a fact or not. That's what's at issue here. And I'm confident as you go back in deliberations, you'll come to that conclusion too. And with that, I thank you again for your service, because it is not easy, and what you're about to do is not easy. It takes time and deliberation. It takes hard work. And I appreciate that you guys are willing to do it. And I reiterate again, that's what makes us a great country. Thank you very much.
Mr. Osborne? Go ahead, Mr. Plaintiff.
Thank you, Your Honor. Nothing Mr. Osborne said about sexually explicit songs out in society refer to specific people in the community like the songs that are at issue here. It's not the same thing. We all know that. These weren't opinions. Mr. Foreman didn't say, in my opinion, Brian Newland is a pedophile. In my opinion, they're all thieves. In my opinion, I fucked his wife doggy style. He said it like they were facts. And I think Judge Hine is going to instruct you, based on everything that's happened so far, that these were not opinions, they were stated as fact. And your job is to decide whether those facts were true or not. And we know they're not. The case isn't about lemon pound cake. It's about intentional lies designed to hurt people, and they hurt people. If somebody in the jury room says, well, what about his First Amendment rights? You know, and the law tells you, that doesn't allow lies that hurt people. If someone tells you it's just artistic expression, he ought to be free to say what he wants, the answer is he's not allowed to wrap up harmful lies into songs, so-called art, put them out there and get away with it. The packaging of the lie doesn't make it okay. The message was clear. And Mr. Foreman doesn't get to wrap himself in the American flag and say, you can't touch me, I can say what I want, no matter how untrue it is, no matter how much pain it causes people, no matter for how long, because I have freedom of speech. He can't do that. I'm confident you'll tell him he can't do that. Thank you.
Thank you, Mr. Plaintiff. Let me acknowledge the Mr. Osborne.
Your Honor, I didn't mean to interrupt you. My thing is, I was gonna ask before we read the jury instructions, if I could use, if we could restroom break for that, because I know it's gonna take some time to read it.
Everybody's gonna stand in their seat and stretch. Nobody's gonna leave the room but you. Because you're pretty prompt with that, so go for it.
Thank you.
I'll just stand up. Blood flowing.
That was true.
Oh, you're in my team. prepare the instructions of law. You've heard the attorney's statements, arguments, you've heard the evidence from the witnesses. The court's duty is to instruct you on the law. And then you have a legal obligation to accept the instructions the way they're given to you. It's your sworn duty to do that. You cannot apply what you think the law ought to be. You're obedient, as I am obedient, to the rules of the law. A person who claims that certain facts exist, in this case the plaintiffs, have to prove them, in this case, by what's called the preponderance of the evidence. You've heard me say this before. I'm going to try to go over things you know, but the obligation is called the burden of proof. Plaintiffs have to prove their facts by a preponderance of the evidence. Preponderance is more evidence in favor of their position than opposed to their position, tilting the scales in their favor. There's one element that has a different burden of proof. Clear and convincing evidence, a higher amount, a greater weight of evidence has to be proven with regard to the knowledge or the motive for publishing. But generally think, okay, can the plaintiffs prove their case by slightly more evidence in their favor than evidence opposed to them? There's two claims, what we've called defamation, and secondly, false light, invasion of privacy. In your deliberations, each of those claims is deliberated separately because there's separate rules for each. I'll give you more. But there's separate law for each of those separate claims. There's 7 plaintiffs, each of whom is entitled to their own deliberation. So when I refer to plaintiff or plaintiffs, what I'm saying to you is that side of the room, but you always have to apply these facts individually and separately deliberate each person's claims. If you rule in favor of one plaintiff, it doesn't mean you have to rule for all the rest of them. And if you rule against one plaintiff, it doesn't mean you have to rule against all of them. So it's not like an all or nothing verdict. It's 7 deliberations. And I'll use plaintiff and plaintiffs interchangeably, just understand the analysis and what I'm trying to communicate to you. So to go back to burden of proof, preponderance is the greater weight of the evidence, evidence that you believe outweighs or is overbalanced by the evidence opposed to it. A preponderance of the evidence is evidence which is more probative, more probable, more persuasive. It has greater evidence value to you. Look at the quality of the evidence, not simply the quantity. If it was only about quantity, there would be more plaintiff witnesses than defendant witnesses, so you'd think, oh, just because of the number of witnesses, someone must prevail, when in fact you look at the quality of the evidence. Don't get hung up on which side called the witnesses. Think about the quality of the testimony, what you took from it, regardless of numbers, regardless of where it came from. If it would turn out in your mind that there's an equal balancing, the evidence opposed to it and in favor of it are equal, then the plaintiffs have not met their burden of proof because they didn't tip the scale slightly in their favor. If you could decide a fact or an item in 2 different ways, you have to decide it based upon the facts, not guesswork or coin flips, or I don't care. So in those areas where it's hard or it's difficult to resolve, you have to resolve it. You can't leave it up to I don't care and I'll just flip a coin or it doesn't matter. Guesswork's not what you're expected to do. The heavy work of sorting out the facts and deciding which side of the scale they go on is the role of the jury. Now, when we talk about preponderance, slightly shifting, we also have to talk about clear and convincing evidence, a different standard for that one element of motive to publish. Clear and convincing evidence is a higher or greater amount of evidence. You have to be more convinced. Clear and convincing means the evidence produces in your mind a firm belief or a firm conviction that that item is true. So preponderance might be, by example, slightly tipping the scales. Firmly convinced is more convinced, greater evidence offered by the plaintiffs with regard to the motive or the knowledge of publication. What's the evidence of trial? Evidence is testimony and exhibits. Evidence is direct and circumstantial. People scratch their heads on this, but it makes sense later. Direct evidence is when a witness has an opportunity to see or hear those things about which they testify. I sat here, I watched the jury take their notebooks and write in their notebooks. Direct evidence, an eyewitness. Circumstantial evidence is different. Circumstantial evidence is when you look at the facts and circumstances surrounding something you saw, and then you make a conclusion that something else actually occurred. I saw the jury box empty, I saw the pencils, I saw the notebooks, I saw the end of the day, the notebooks were all open, there were words written there, so it's circumstantial evidence that the jury took notes. I didn't see you take notes, but from the facts and circumstances that I did see, it's a reasonable conclusion of fact that you did take notes. Why do I tell you that? Most evidence came at you both directly and circumstantially. Things that I personally saw, and then things that happened as a result of what I saw. Circumstantial evidence is fair game as much as direct evidence. Direct evidence isn't better. You might think it's better when in fact it's not always better, because the witness didn't tell you that they were blind when you thought they saw something, or it was foggy, or the lights were bad. So when you think about the evidence and how to weigh the quality of it, what a person saw, what they heard, what they personally experienced is good evidence, direct evidence. But so is the circumstances around that testimony. They're both fair game. Often people infer that something exists based upon the circumstances and inferences. I inferred it's a reasonable circumstantial evidence that you wrote in your notebooks. That's fair. But I'm not allowed to infer, because you took notes, therefore you also did something else. You can't stack an inference that something else occurred on top of something else you thought occurred, on top of something else that could have occurred. The idea here is what we call remoteness. It gets more and more unreliable the more remote you get from the first circumstantial evidence. If you want to say the circumstantial evidence is reliable, great. If you want to infer that that's reasonable, great. But don't stack another, well, now I suppose something else happened, and if that happened, then something else should have happened. It's stacking, it's called remoteness, then it gets unreliable. With regard to the exhibits, you saw exhibits, there was testimony related to them. Consider whether the exhibits are in fact what they're portrayed to be. You decide what weight, if any, the exhibits have to have when thinking about the testimony involving them. Exhibits in video can speak themselves, but sometimes paper and other exhibits don't. So you have to consider what the witness said in light of how the exhibit was portrayed. Don't make inferences or conclusions based upon the number of exhibits. Remember, I want you to look at the quality, not just simply the number. Like theoretically, the plaintiffs had more number of exhibits than the defendant. Don't care, don't count numbers. Look at the quality, make the content important. You'll have like physical, tangible paper exhibits back there. When you get to the video or the data-driven exhibits, you'll have a computer back there so you can use that to look at the exhibits. So if it never works that way, so I always offer the bailiff services that he can come back and, as you saw, make the technology work. So if you struggle back there with plugging in a thumb drive and finding the drive and then turning it on, we would expect that. I'll tell you how to communicate with us, but just ask for help. We'll send back a very capable bailiff and he'll save the day. Evidence is not what the lawyers say. You heard opening statements, closing arguments, that's not evidence. It's helpful, it's necessary, it's built into the system, but it's not evidence. If a statement was asked and the question was not answered, there's no evidence from the question. I did that once or twice to show you how it works. Just, you might have thought the answer was going to be yes because the witness was shaking their head yes. The witness was, yeah, I understand the question, and the answer is no. So you can't use body language to get an answer that wasn't spoken from the record. I don't think that happened too often. But remember where the evidence is. It's the exhibits and the witness statement, not the lawyering side of the case. There was times where I sustained objections and handled the lawyers the way I thought was necessary. I always ask people to apologize or accept my apology if you thought how I handled the lawyers is any kind of a comment upon the quality of the case. Like, I try not to do that. But you might misunderstand that in scolding a witness or handling a lawyer, I was expressing an opinion. I love it when you guys show up because I don't have to decide. It's like I always try to make sure I'm neutral in my facial expressions and my voice tone, but sometimes I just don't get that done. An important role for the jurors is to weigh credibility. Credibility is assigning believability, assigning weight to the evidence, assigning weight to the witness testimony, assigning weight to the exhibits. When you weigh evidence, you're basically deciding truthfulness. And as odd as it sounds, it's what we do all the time. We weigh credibility continuously each day. In weighing credibility, you should consider the appearance of the witness on the stand. Consider the manner in which they testified. Did it seem straightforward? Did it seem honest? Did it seem evasive? What did it seem to you? So you're using your eyes and you're using ears to weigh credibility. Think about how reasonable their testimony was in light of the subject matter of the trial. Consider education, interest, bias. Consider if they were frank with you or not. We use these tests every day to decide whether we want to rely upon or find a person believable or not. As I told you before, every witness took an oath to be honest in their testimony. The oath does not bind you that just because they're talking, I have to believe it. In fact, you have to parse it out, because people could very honestly get up and say, I believe this to be true, when in fact they're misunderstood and wrong, not lying. So recognize you can parse the evidence. You can believe everything a witness said. You can believe nothing a witness said. You can pull out the pieces you think are credible and ignore those that you think are not credible. And then you shuffle that entire deck with every witness along the way. As a rule, we want people only to testify, general rule, about things they heard and experienced and saw, firsthand testimony. So that's the general rule. But then we violate that general rule because we let people express their opinions about what the facts or circumstances mean that they experienced. So in deciding what their opinion means and how you weigh their opinion, you do the same thing. You're allowed to hear their opinion. It's evidence. But you have to, again, parse it out in terms of the credibility test. A person can give you an opinion, and you might go, I don't believe that because that's not in their subject matter. Or they don't have enough knowledge. Or their emotions got the better of them. Or they have an interest or a bias or whatever. And you might go, no, it's a completely valid opinion because of whatever credibility factors you have. So we give you direct testimony, we give you circumstantial, we give you opinions, and then tell you to weigh out those things that you find believable, credible, and otherwise. In this process, the jury sits around as a committee. And it might be that you find a person credible, the other person finds somewhat credible, and the other person finds not credible. Expect that to happen. And then resolve those differences back there. There's more about that later, but in this whole deliberation process, that's normal. Somebody said while they were here, yeah, I'd served on jury. No, it wasn't easy. It's not meant to be easy, it's important. I just have to explain the rules enough and then tell you don't get your feelings hurt. when you get back there and begin the discussion. The instructions I gave you so far would be relatively common in most trials, because those are general rules for how to do the job as a juror. The next set of instructions in the middle, I call substantive instructions. These are the law that applies, the rules that apply to this set of facts, these claims. You'll have sets of these instructions to go back over, so I have to read them to you in the party's presence, but you're not expected to remember all this. You'll have your opportunities to go back over it and get schooled later. So these are the substantive instructions. Again, two claims. One's called defamation. The other's called invasion of privacy based upon this false light publicity. They have separate instructions. I put them right next to each other. But the rules for the one claim are not the same as the other. There's overlap, but they are a separate set of rules. So don't apply the rules for defamation to the false light publicity claim, because you went across the line of their two separate causes of action. With regard to defamation, each plaintiff claims the defendant defamed him or her that then caused them damages. To establish defamation, each plaintiff must show that a statement, that could be oral, written, video, was portrayed a fact that was published. So the statement was made, or statement of fact was portrayed and published. Second, that the statement was untrue. Third, that the defendant acted with malice, actual malice, or reckless regard for knowledge of the truthfulness, and that they suffered injury. I'm going to break those four apart. Okay, so again, the statement was portrayed as a fact. It has to be published, so that's all rolls together. That the statement was untrue. The defendant acted with either actual malice or reckless regard about the truthfulness of it, and then that caused injury. Plaintiffs are considered public officials. You heard a lot of that. So that's where the clear and convincing evidence standard applies. So what you're doing is taking on the element of the defendant acted with malice or reckless disregard about the truthfulness of it. That's the higher clear and convincing proof. So on that element, it's not just a preponderance. On that third element, it's thoroughly convinced about his motive for publication. Clear and convincing evidence means you're thoroughly convinced about the truthfulness of motive for making or publishing the statement. What's actual malice? This knowledge in the publication. Actual malice occurs when the defendant makes a false statement with knowledge it's false. The second part of that test, it's either published with actual malice or published with a reckless disregard about the truthfulness or not. So reckless disregard means that a defendant acted while aware that the statement was probably false, or that the defendant entertained serious doubts about the truthfulness and didn't inquire. The defendant's failure to investigate may be considered evidence of reckless disregard or evidence of falsity when the defendant had serious doubt about whether it was truthful or not. So actual knowledge of falseness or reckless disregard about something that's probably false. Those elements have to be proven by the higher amount of evidence. A statement is false when it's not substantially true. It's substantially true when the essence of the statement is true, when you think about the statement as a whole. The defendant's statements or portrayals must be given their ordinary meaning in that context, in that circumstance. So you can't just pull a line out. You have to look at the whole portrayal of the statement. In deciding whether the statement is false, you're not to consider the defendant's subjective belief. You consider whether it's true or false from an objectively reasonable perspective. So it's your perspective about truthfulness, not what the defendant thought at the time, because we can all think of things that are unreasonably thought. So we apply an outside standard, an objective standard, not the defendant's subjective belief. Now, this idea about the concept of truthfulness is where we find the fact that truth is a defense. So if the statement is true, then there can be no defamation. Plaintiffs also have to prove that the statements were published, portrayed, made. Published means that the statement was read or heard by another person other than the plaintiffs. From the testimony, as a matter of law, the courts has determined that publishing or portrayal is not an issue. Nobody pushed back. It's not anything you have to decide. I'm telling you as a matter of law, that element is uncontroverted, that the defendant published, the defendant portrayed the statement. So of those four, one's been resolved by the court because there's no contrary evidence. Now you're down to analyzing those three statements, elements, if you will. You need to know how to differentiate between facts and opinion. In a defamation claim, this is important. This is over on this side of the first claim, fact versus opinion. The distinction between portraying a statement of fact and portraying a statement as opinion is crucial. It's an important distinction. Portraying a fact or portraying an opinion. Only statements of fact can be the basis for a defamation claim. Statements of fact could be untrue, which is the nature of a defamation claim. If I'm expressing an opinion, there's no way to decide whether it's true or untrue, so you can't defame someone in expressing an opinion because there's nothing verifiable about it. It's an opinion. So a defamation claim has to involve an untrue fact. To determine whether a statement is fact or opinion, you apply these four factors in their whole context. You look at the specific statement, the language in the statement. Consider, importantly, whether that statement is verifiable or not. Then apply the general context of the statement, and then think about not only the context of the statement, but then the broader, how the statement could be received or heard. Start with the statement, is it verifiable? Consider the circumstances of the statement in its context, and then go farther out to the statement's circumstances in general. Look at the precise wording. Determine whether a reasonable hearer or listener would view the words as portraying fact or portraying opinion. If a statement is made and it's considered an opinion because it's not verifiable, there could be no defamation. If a statement is made and it contains verifiable information, then it can be the subject of a defamation claim if the verifiable statement is untrue. If you find that the statement was portrayed to the public as a fact, that the portrayal was false, it's a fact and it's false, plaintiffs have proven their case. If you find that it's not a fact, or that the fact was true, then the defendant prevails. This is why I give it to you in writing.
Okay, I forgot about that.
General instructions for defamation are done. Those rules apply to that claim. These rules apply to the invasion of privacy false light claim. There's only one place where I'm going to tell you to overlap the instructions. But so don't overlap all the first instructions in the second bucket, separate set of rules. The person who invades the right of privacy of another person can be subject to liability and the harm that comes from invading that other person's right of privacy. The right of privacy is the right of a person to be left alone. It's the right to be free from the unwarranted appropriation or the exploitation of a person's personality or their private affairs in such a manner as to outrage or cause mental suffering, some sort of shame or humiliation to the person. Each plaintiff claims the defendant violated his or her right to privacy by publicizing false information that places them in a false light in the public. Each plaintiff must prove that the false light in which they were placed would be highly offensive. It's a highly offensive place to a reasonable person, not their subjective, but would a reasonable person find that they were put in a highly offensive place. And the defendant had knowledge of or acted with reckless disregard to the falsity of the publicized matter. Reckless disregard, falsity, and actual knowledge are the same definitions from the first section. So that part of the first instruction you can carry over. Actual knowledge, reckless disregard, and falsity, I'm not going to redefine. That part you would read over. But it's a different test. Was the particular plaintiff put in a false light by the false information? False light means the defendants know that the plaintiff, as a reasonable person, would be justified in feeling seriously offended and aggrieved by the publicity. Seriously offended and aggrieved by the publicity. The plaintiff's privacy is not invaded when it's an unimportant statement that's made. It's only when there's such a major misrepresentation of the plaintiff's character, history, activity, some fact, that it might be reasonably expected that a reasonable person would be highly offended. Determine whether the statements made by the defendant would place a reasonable person in a position of false light, not merely whether the plaintiff believed they were in a false light. So this is the objective perspective that we use for juries. You're the outside public looking in. Do you consider it reasonable or not that they would be highly offended? It's not their subjective belief, it's the public's perception. To be highly offensive, the plaintiff must be justified in the eyes of the community as feeling seriously offended and aggrieved by the publicity. The statement must be such a major misrepresentation of their character, of their history, of their activities, of their beliefs or facts about them, that they would be seriously offended in the eyes of a reasonable person of the public. False has the same definitions I gave you, not substantially untrue. The fact versus opinion distinction doesn't apply from that, so you don't have to do the fact versus opinion analysis. If you find that any one or more of the plaintiffs proved all the elements of false light invasion of privacy, then you would enter a verdict in their favor. If you find that any one or more of the plaintiffs did not prove all the elements of false light invasion of privacy, then you would rule in the defendant's favor. I'll say it again, there's 7 determinations on false light, there's 7 determinations on defamation, and you make them separately. If you find for a plaintiff on either one or both of their claims, then you go to the question of whether the defamation or the invasion of privacy caused damages. There always has to be a connection between the false statement and the damage, or the false light offensive position they were put into, and the damages. A person who seeks to recover damages must prove not only that the other party caused the harm, but also that the conduct proximately caused them injury. Proximate cause is an act that in its natural and logical sequence caused the injury. There was an example of the defendant could have caused, but was something else actually the cause. You have to sort out whether the person's injury came from the defendant's conduct or came from somewhere else. With regard to damages, the purposes of damages are to compensate a plaintiff for injury to their reputation, for any kind of monetary loss, for emotional distress, so it's compensation, to vindicate the plaintiff, which helps restore their reputation, and to dissuade others from publishing defamation statements or false light statements. If you find that any one or more of the plaintiffs' claims should be ruled in their favor, then you have to have the greater weight of the evidence, a preponderance of the evidence about the amount, not clear and convincing proof about damages, but in your deliberations, slightly more evidence in favor of the amount to award is the test, the burden of proof. Take into consideration all the facts and circumstances and evidence, decide what amount of compensation should be awarded to each particular defendant, or plaintiff. These are the kind of types or examples for which you can award money. Harm to their reputation, including exposure to public hatred, public contempt, ridicule, or public scorn, and or loss of professional income and or out-of-pocket expenses, and or physical, mental anguish, pain, and suffering, loss of society, companionship, and friendship. Those are all eligible factors or categories by which to compare or measure damages. It could be that the award of damages is not easily determinable and you can't put an amount on it. You can still order what's called nominal, or I'm going to use the word token damages. So if you find in favor of the plaintiff, then you have essentially the opportunity to go from 1 to wherever. Nominal or token would be the 1 or 10 or some low amount as a statement that they prevailed and entitled damages, but you're not bound by anything more than 1 in your deliberations. But if you find for a plaintiff, then there has to be an award for damages, assuming there's a causal link between the defamation or the false light and injury or harm to reputation, emotions, etc. As a matter of law, the court determined previously that the claimed damage to the defendant's home was permitted under the circumstances of serving the search warrant. Therefore, you do not make a reduction for any damage that the defendant said happened to his home during the search warrant. The court previously found, as a matter of law, that that's expected or permitted as a result of serving the search warrant. So you don't subtract based upon whatever you think happened to his home. In your deliberations, a plaintiff cannot have double recovery. If you find defamation and invasion of false light privacy, you don't issue an award under each category. You can't award pain and suffering, say this, emotional distress once and then emotional distress twice. You would issue one order as long as there's either a claim for defamation or a claim for false light, invasion of privacy. Don't double up if a plaintiff prevails on both claims. Your verdict form doesn't really make that possible. You'll get there, we're getting close. Another concept that came up earlier was something called punitive damages. You are advised that punitive damages are not a part of the deliberations given to you right now. I haven't talked about punitive damages. Punitive damages are meant to be punishment damages for conduct. That's not a part of your deliberations. You're deliberating what we call compensatory injury-related damages. An award of punitive damages can only be given if there is a compensatory damage award. If a compensatory damage award is given, then you come back with a different set of instructions and you have arguably a second deliberation about punitive damage. You don't have to award it, but they aren't all lumped in. So don't think in this first phase, oh, the punishment, I was really mad. That's not where we are. If you find any plaintiff prevails on either claim and it caused injury, compensatory, actual repair damages, if you will, are what we're here for, not punishment. That's a second deliberation. The verdict forms aren't that hard to understand once you know what you're doing. Each plaintiff has 3 pages. Page 1 is the claim for defamation. We, the jury, being duly impaneled, find in favor of, and then it says Sean Cooley or defendant, circle 1. So you have to circle whether the defendant prevailed on Sean Cooley's claim for defamation. Then there's signature lines. Regardless of that verdict, you go to the second claim. So the next form is, we, the jury, find in favor of Sean Cooley or defendant for the false light claim. The instructions at the bottom of each page say, now go to the next page. If you find for that plaintiff on either of the first 2 forms, then you go to form number 3, which is damages. Damages is 1 line, where you put a number in. You can take notes and you can split it out, you can do calculations, you can decide how you get to it, but there's 1 line. So that would be for Sean Cooley, and it says Sean Cooley on the first 3 pages. And then the next 3 pages say Justin Cooley, same 3 pages. So the first 2 pages find in favor of that plaintiff or the defendant, circle 1. Next one in favor of that plaintiff or defendant on the second claim, circle 1 of those options. And then you go to the damages form only if the plaintiff prevailed on one of the first 2. They're all numbered, they all have names on it, they should be easy to follow. You can tell me later. What do you do when you go back there? The first thing you officially you need to do is pick a foreperson. Now the foreperson's not the shop foreman, they're not the boss. They don't tell you what to do. The foreperson's job is to organize the discussion, engage people, keep track of the exhibits, be the committee chairman. But the foreperson doesn't convince you to do what they want, they organize the discussion. There's no way to pick a foreperson. You can arm wrestle, throw fingers, draw names out of a hat, don't go to the bathroom first, because you very well could come out the foreperson. I don't care, I've heard people say that, they pick them because they weren't there. It doesn't matter, I can't tell you how to pick one, just get one. Throwing fingers is fine, it takes too long. You probably already know who's willing to do it, or maybe you've talked to each other enough, or you just say, sorry, you lose, you're it. But it's just organizing discussion. That's all it is. Just organize the discussion, make sure nothing leaves. You'll have in your possession the verdict forms, the exhibits, you'll have copies of these instructions. Keep all that back there. When you come out, the only thing left to bring back out here should be all these verdict forms. Leave your notebooks back there. Everything else in the foreperson should make sure that that goes on. How do you deliberate? Generally, the advice to you is to go back there and start talking about the case, replay the witnesses, but don't just say, I think something ought to happen. When you come out with your first opinion and then start discussing it, a lot of people realize their first opinion is not their best opinion. But once you threw it out there, then you got to figure out, how do I get my pride back and retool? So generally, don't go back there and just say, here's what we ought to do. What do you think about this witness, and how did this one come across, and do you understand the rules? And start into this discussion process, however you can do it. But eventually, then you're going to need to start getting to the point where you see a consensus is being built. If you immediately express an opinion, changing is sometimes hard, so work together to build a consensus. Consult with one another in the jury room, deliberate with a view of reaching an agreement. You can do so as a group, but without surrendering your own conviction. each of you ultimately has to decide this case for themselves in this deliberation process. You might find somebody leaning on you to change your opinion. That's good, unless you feel pressured against your will to change your opinion. If they come at you with good arguments, maybe you should rethink your position because their arguments really are good. So like a certain amount of give and take and tension is usually the sign of a good deliberation. Just don't take it personally. Never surrender your own personal convictions just to get along. Don't be influenced by considerations of sympathy or prejudice. The law does not expect us to be robots and have no sympathy, no emotions, no prejudice, or no biases. That happens all the time. You have to set those aside. You're required to disregard them, to make your verdict carefully, to weigh the evidence, consider disputed questions of fact, apply the law to try to reach a verdict which the parties would be considering fair to both sides. Fairness is a big thing. Is this verdict fair to both the parties? Consider all the evidence regardless of who brought it forward. Do so with intelligence, impartiality, without bias, without sympathy, without prejudice. During the deliberations, if you have questions, you're welcome to write them down, which then comes to me, which goes to the lawyers to get you an answer. Like a magic doorbell. Knock on the door. Okay? The bailiff's like within earshot. He doesn't have the cup up against the door. So like pound on the door enough to get his attention. He'll come back, get the question, give it to me, I'll huddle with the lawyers, get you an answer. So when you get back there, there's a problem, you don't understand something, you want more information, you can get more information. Like we'll try to make sure you're not starving, like creature comforts will be provided. Like we're gonna run into the lunch hour, so there's a way of taking care of it. I heard it yesterday, they'll do it today. So like we're gonna wanna cover all those bases. The clock is yours when the deliberations start. You watch me pay attention to the clock, right? I don't have a clock because you do. So how much time you need is up to you, not up to our expectations or our time commitment. We gotta make sure that when you deliberate, you don't do so out of like human denial or fatigue. So yeah, we're gonna watch to see how that goes. Like you might have me send you a question saying, is everybody fine? Are you awake? Do you need coffee? Do you need food? What do you need? One jury kept going, my personal record's 1:24 a.m. because that's what they wanted. If they didn't want to go home, they weren't not coming back tomorrow because they were locked in and doing a good job. But it wasn't my clock, it was theirs. Until the verdict is announced in open court, you cannot indicate to anybody what it is. When you knock on the door saying we have a verdict, the bailiff will come, he'll tell me that you have a verdict. The foreperson brings the forms out here, and you hold on to them till everybody's here, and then we open the verdicts in front of all the parties. Don't say, oh, so-and-so, and this is the outcome, because the bailiff doesn't want to know that, and he shouldn't know that, because it has to happen in this room. Up to this point, like I've told you, you'd like not to talk to people, that still applies. Anybody outside the jury, that's off limits. If we deliberate today, you went home tonight, came back tomorrow, the rule's especially important. You can't tell anybody anything at all. Once the case is done, you can, in case I forget to say that. With regard to deliberations, I've got 10 of you and 2 extras. So the 2 on the end, 17 and 19, you're alternates. So you don't deliberate, but you're not done. You're what we call insurance. There's no guarantee in an hour somebody's not going to get a call that they have to go, or that they hit the floor, or somebody had an accident, or the baby came early, or whatever it is. So you're not done. You're charged to not talk and to just wait. It's a luxury to have extras. I understand what I just did to you. I get it. But the number of times the jurors slot back in is not the majority, but it's enough that we're glad to have you for a reason. These folks get locked down and something happens along the way. We can't lose 3 days of trial work because somebody went through a stop sign or had a flat tire on a curvy road. Then all of a sudden you're back, we start all over, and the case gets done. So make sure the bailiff has your phone number. If you can be within like 15 minutes of the courthouse, I don't know what that means. If you live farther, just make sure Chris doesn't have to drive far to get you. He's not going to anyway, right? But he's big enough to, you don't want to cross him, kind of guy. Anything you want me to deal with in the instructions, Mr. Flegler?
I had two minor issues.
Okay, we'll talk over there. Mr. Osborne, you got anything?
I do have something, yes, sir.
Okay, we're just gonna see what I didn't do right, but we're close. The vote is 6 out of 8, not 8 out of 8. It's the next paragraph down. So I've got 8 jurors. When you go back there, 6 and 2 is a vote in favor or opposed. So you always have to have 3/4. So if you take a vote and it's 6 this way and 2 that way, that's enough votes. It does not have to be unanimous to prove a case. In a civil case, it's 6 out of 8. That a big deal? Yeah. I ever forget it? Yes. It's 6 out of 8. So you can have 2 people say, I don't agree, and if 6 people do, that's a verdict. And then the emphasis for the 2 alternates is not only not talking is important, but not talking to the media is important. So if you get hounded, it's anybody in the universe. Because you're still in the panel, and then if the jury reached a verdict without you, you're going to get a call saying, you're done, and now if you want to talk about it, you can. Anything else, Mr. Klinger?
Nothing from us, Judge. Thank you.
Mr. Osborne?
Your Honor, I just renew any objections for the record, but nothing else other than that.
Fair enough. Overruled.
Thank
Or
you.
ruled, depending on what it did. There's a few typos. It'll be like 5-10 minutes before it gets you some sets of instructions. When you look at the instructions, if you have a question about something, read the whole paragraph, not just the one sentence. Like you always think, I want to know more about something. The answer might be 3 words, but read the whole paragraph to do it. So you start your deliberations. We'll get the exhibits back to you, cleaned up sets of instructions. And thank you for your attention so far.
Yeah, are you taking our lunch order?
Sure am. Shirley, we get their phone numbers.
Yes, I will.
I need to leave that way right there.
Leave this later?
Yeah, and then, if you would have to come back and deliberate, you'll have to notice that. We don't look at them or anything, even afterwards, we just tear them out.
You wouldn't be able to follow me anyway.